get at a separate problem, which is unsubstantiated statements. This project will cause field mice to do X, because I think so. Or will cause bad traffic impacts, but I'm not a traffic engineer and I'm not providing you any factual basis for my opinion. So you have sort of allowable criteria as one thing to think about, and then is the statement or testimony that you're receiving substantiated in a way that you're justified in basing a decision on.
Great point, and it gets back to that, is there substantial evidence in the record to support the finding you're making on the field mice? If it's just an off-the-cuff comment, then that should not be considered.
No, but they could come forward if you're doing a wind farm and say, the wind farms are known to kill migratory birds. You're in the flight path of the spotted owl. Here's the report that says windmills kill birds. That then can be a criteria that we add in as part of the process that says you need to look at Endangered Species Act or environmental things.
And you're certainly free to do that up front legislatively. You can't do it during the process on the permit, though. Too late. You understand that?
No, we may not know all the criteria going in that may be applicable.
No, disagree. Sorry. That's the whole point of what I've been talking about. The criteria are established by the time you go through this quasi-judicial process. The minute that application comes in, it locks into whatever criteria you've already enacted through legislation, through ordinances. Oh, you can't change that midway through and go, you know what, we should also consider impact on spotted owls or migratory birds or something like that.
If there's proper finding that the Endangered Species Act should be applicable for some reason or another, that's an existing legal code that I now have to bring in if there's substantial finding that says your project violates Endangered Species Act.
Okay, I have a couple of comments on that. That's way outside
I'm
the
reaching.
school book. No, not necessarily, but
quick comment. This relates to Bob's comment about traffic engineering. This is traffic. These roads are flying in, right? Right, and we have a report.
there's speed limits for migratory birds.
What is the speed of the wing beat of the
Yeah.
swallow?
What movie is that from?
There was a Python in the Search for the Grail or something.
Yeah. All right. So real quick on your point, and Bob may want to answer this. I have a couple of points. One, with respect to the Endangered Species Act, presumably that would have been reviewed and dealt with at the SEPA environmental stage and should have been resolved or evaluated by staff as part of the State Environmental Policy Act review and application of that, the ESA, number one. Number two, if it wasn't, I'm not sure that would have any applicability unless your code specifically said and must comply with all aspects of the ESA. I don't know, what's your...
Yes, generally there's some exceptions, for example, with what FEMA has been trying to do with the salmon listing and application of its community rating system regulatory criteria and applying those to local project decision making. So that's I think maybe what Councilmember Holloway is getting at, because Snoqualmie has lengthy experience with FEMA and was involved in one of the cities in that federal litigation brought by National Wildlife Federation.
Okay, good point.
Trying to make, but it's a pretty limited and specific
What I'm
scenario.
saying is, the code is that thick.
Yeah.
And we'll pick out 12, 20, here are the criteria. At some time during that process, we may discover, oh, we missed this existing part of the code which should be applicable, and during the process, bring it in.
Okay.
So I don't view the criteria as, I view them fairly set, but there's opportunity if we miss something to bring in.
Okay, so here's my suggestion, and then I'll move on. And that is, I would raise that issue with your city attorney at that point. If it comes up and you're going, I'm not sure if this ESA, Endangered Species Act criteria should apply here. Bob, can you give us an opinion on that? Bob will say, you know what, let's discuss it in executive session, or he say, I know the answer off the top of my head, or we need to look into that. let's continue the hearing, something like that. That would be my response, because it's gonna be very fact-specific, and it may not be, I'm just thinking that should have been dealt with, or at least addressed or identified earlier at the SEPA stage, which gets resolved before the application gets.
Yeah, I agree, but I also.
Well,
we're humans.
No, I hear you, okay.
Right, but it does, the one state statute does say that you can't use project review as an opportunity to revisit your use regulations. If you know, in the planned commercial industrial chapter, for example, if it has 12 criteria, and during the process, someone says, it would be great if it had this 13th criteria, that's X, the statute says we don't get to
Talk
do
about
that.
that afterwards.
Absolutely, and that's also a vested rights issue, and I actually quoted that in one of the other slides. All right, real fast here, and then I'll kind of wind down and take questions or whatever. But the findings of fact, they apply to virtually everything, but here's the slide I really want to show you. Findings should support each criteria for approval. So if you've got 12 criteria for approval of a conditional use permit, for example, you should have at least one finding related to each one of those criteria. In other words, a finding of fact saying, you know, 3 people testified that, you know, this project would have, would add, you know, 12 new car trips per hour onto, you know, Highway 5, which runs in front of the property, and therefore is an adverse impact on this criteria, or whatever. I'm doing this off the top of my head, but you need to have findings for each one of the criteria. The findings need to show, and this got to the Mr. Sunwall's question about, well, how do they know what I'm thinking? Well, this is what the findings are exactly supposed to do. They're supposed to show you your decision-making process. They need to be clear, precise, and understandable, but more importantly, let me just run through real quickly. Here are some examples, non-exclusive list of findings and conclusions that are not lawful, not defensible, you don't want to do. You're making findings and conclusions, and Bob touched on some of these, without evidence in the record to support them. You're just making up stuff. Okay, and that's people coming in saying, well, this is going to increase traffic significantly and cause safety hazards. How do we know? Is there a report from a traffic engineer? Yes or no? No, that's just pure speculation or conjecture. Okay, you know, this is going to cause a 40% reduction in the fair market value of my property, which is a block away. You have an appraiser report? First of all, is that even a proper criteria? But you better have a report. Findings and conclusions based on a belief. If you see these words, if these words are used as part of a finding of fact, it's likely invalid. Okay? Those words come out of court cases invalidating findings of fact. The city believes that this will cause an increase in traffic, or feels that this will impact migratory birds. You know, those are generic, non-specific, non-evidence-based words. Statements of the positions of the parties. You don't make a finding of fact saying, well, the applicant stood up here and assured us that this will have no impact on the stock of housing in the city of Snoqualmie, or whatever. That's a statement of, it's like a campaign statement. All right, summaries of evidence. So, and I've seen this over and over. Parties, particularly the developers or applicants, love to put together summaries of evidence that they have seen so far, and say, well, here's a summary of all these 25 letters that were submitted, and here's how it's summarized. That should be ignored. The actual letters should be considered to the extent that, and applied to the extent they relate to the criteria. But the summary, no. The findings based on stereotypes or popular prejudices. This is a good one. I've seen several decisions invalidated because there's a finding saying, well, we assume that if this developer is allowed to develop this project and we condition it this way, that they just won't even comply because this developer's got a history of not being a good steward or whatever. You don't guess at that. We don't assume non-compliance. You actually assume compliance. Findings that the project would negatively impact other properties. Again, unless this is clearly established as criteria in your code. Findings relating to the owner. This owner's an ass. I've actually seen that in a decision years ago, and I don't know if they used the word, pardon my French, but ass, but I think they actually said a jackass. I think that was the word that was used. It was terrible, absolutely terrible. I'm not making this stuff up. You can't make this stuff up. Community displeasure, NIMBY complaints, 4 people showed up and said that this is going to impact their ability to have safe sanctuary in their backyard, that kind of thing. I'm going to go through. I wanted you to see this. This is all in your materials, folks. This is more of a reference thing, but keep in mind when you're drafting decisions, making decisions, putting in findings, how you use words. These first, category are words that they're not necessarily not lawful to use, but they're high-risk words, and they're high-risk because they're vague and ambiguous. I don't know what appropriate means. This will, destroy the unique character of Snoqualmie. What does that mean? It will provide a benefit to the city. What kind of benefit? This will have significant impact. What's a significant impact? Well, a 25% increase in the number of vehicle trips on the street. That's different, okay? That's specific. And bear in mind, we use words like shall, will, must, required, mandatory. Those have legal significance. They're legally mandatory words. They require a result or an action. If you use the word should, may, prefer, things like that in your decision, they're optional. Okay? So if you're saying as a condition of an approval that the applicant should put in landscaping around the perimeter of the project, and the approval goes by, nobody appeals it, and they don't put in the landscaping, you go, well, you violated a permit condition. No, I didn't. You said should. I decided not to. Well, wait a minute. We told you, no. Should means it's optional. If you meant you wanted us to do it for sure, you should have said shall. I'm not making that up. That's the way the law works, okay? All right, I'm going to zip through. The hearing examiner, I've already talked about that. I'm not going to beat that horse, but I urge you to use a hearing examiner to the fullest extent possible. I urge you to use a hearing examiner for final decisions. I noticed I did look at a couple sections of your code. You're using one, which is good, but I would use them in a greater extent to make final decisions on quasi-judicial applications rather than making, for example, recommendations that ultimately, or making decisions that can be appealed to the council, kind of defeating the purpose. And I'm happy to come back and talk more about that. By the way, I'm not a hearing examiner. I don't get any money for this. People always go, well, you really push hearing examiners. You get a kickback? No, I don't get any kickback, but they're great risk management on every level for a city. And I will tell you, I can tell you this honestly, of all the hundreds of cases I've defended over the years, I can think of only 5 that arose out of a hearing examiner decision, and of those 5, maybe 6, all but one of them we won at court. So the other huge majority of the cases that go up, there's a lawsuit over, arise out of decisions by some entity like the council other than a hearing examiner. So there's a reason why more and more cities use them. So I'll leave it at that. A whole bunch of good reasons. Just mention this, by the way, the biggest one for all of you, it really avoids any potential appearance of fairness issues. You don't have to worry about that. And it avoids any potential personal exposure. The appearance of fairness doctrine, I apologize because I kind of went way over, but I've got a kind of quick summary of that. Just keep it in mind when you're handling quasi-judicial matters. It applies. It's an outgrowth of Watergate. It's codified at RCW Chapter 4236. There's tons of kind of summary papers out there on the appearance of fairness doctrine. It's a now statutory requirement for all quasi-judicial decision-making and decision-makers. The 2 key parts of this, your hearing that you hold, whether, again, it's a recommendation hearing or a final hearing. And by the way, hearing examiners are governed by all this too. Right? They don't get a pass on this. It's the same rules for a hearing examiner as it is for council, planning commission, any other quasi-judicial decision maker. The hearing and the decision must be fair in fact, and more importantly, it must overtly appear to be fair to a disinterested third person. So somebody sitting in and watching your hearing should come away with that going, well, this appears fair to me. It looks like it's balanced. They did a disclosure. Nobody's got a bias or an interest. Nobody's got any kind of social or familiar relationship to the applicant or an interested party, etc. And this is the test, where a reasonable person apprised of the totality of a member's personal interest or involvement be reasonably justified in thinking that the involvement might affect the member's judgment. That's the test. And it's a pretty broad test. And this is why I mentioned earlier, and I'll get to the kind of nitty-gritty here. It applies to all these folks. I mean, everybody we're talking to here, planning commissioners, council members, hearing examiners, some cities still use Board of Adjustment, permit staff, etc. If it's quasi-judicial application comes in, they're governed by appearance of fairness. You got duties and obligations to act fair, be fair, disclose conflicts, not be biased, and basically these are the kind of key, not a full list, but most of the primary prohibited acts. And they're obvious things. They're the kinds of things, think about again, you're a judge. You walk into your trial, you're the plaintiff or a defendant, either suing, getting sued, you go into trial, and you find out that the judge, used to be married to the defense attorney's wife. Okay, we got a social relationship, you think you're gonna get a fair hearing? I mean, those are the questions you ask. Ex parte communications, you're at Starbucks or the local coffee shop and you're talking to an applicant about the project. You've got a clear ex parte violation here, or you're talking to a citizen saying, hey, understand that Walmart application's coming before you in a couple of weeks. I'm going to be at that hearing. You better do the right thing. That's where you need to abort that right away. Thank you. I'm sorry, I can't talk to you about that. It's coming before me. Got to be disinterested decision maker. Anybody that's got personal benefit, if you own property, adjacent to or substantially near a project site that might be impacted by it. If you've exhibited hostile or rude or antagonistic comments to one side or the other, like, I hate developers, they're just terrible, they're just destroying the city, and that kind of comment, again, will show or establish, or may show or establish bias, which will get you disqualified. And real quick here, I'll just go on these rules. These are simple rules, relatively simple as things go. No ex parte contacts with proponents during the pendency of an application, and that means from the minute the application comes in. You know about it, hear about it, or are anywhere aware of it. Keep that Chinese wall built so that you don't have the contacts with proponents, opponents, or anybody that's got some interest in the application. Disclose the substance of the communication and offer rebuttal if there's a problem. And actually, let me go to the real, tell you what to do. My rules. This is kind of the big stuff. If in doubt, when you're overseeing or adjudicating a quasi-judicial application, first rule, and I'm assuming that you folks probably all, at the inception of a hearing, do an appearance of fairness disclosure or bias disclosure or something. I'm sure Bob will make sure that happens. That's great. You need to do that. If you're in doubt at all about, I talked to Mrs. Smith at the Starbucks 3 months ago, and I think we talked about this Walmart, and I think she was telling me some stuff about it. If you're in doubt, I'm not sure what all we said, disclose it. Disclose. I cannot emphasize that enough, because if you disclose it and give the, just key details, who, what, when, where, etc., and nobody objects, any further objection is waived. It's gone, you're safe, you can stay on, you can adjudicate it. If you don't disclose and somebody finds out about it later, that's going to be grounds potentially for invalidation, okay? So, I just can't push that. I wish I had a whole day on this. I'm sorry, folks. This is a seminar in and of itself. This has turned into just a sticky wicket. My advice to you is assume any emails you send or receive, or social media communications through Instagram, any of the other social media, Facebook, etc. Can be used to show an appearance of fairness violation. So if you're making statements on Facebook about, I can't wait to get that Walmart application in front of me, they're going down, or something like that, you better disclose that. First of all, you shouldn't do it. Secondly, if you've done it, you need to disclose it. But aside from that, I wish I had days or a full day to discuss all this, because these emails, social, Twitter, Instagram, Facebook, all this, have huge, horrible implications for cities in terms of appearance of fairness, Open Public Meetings Act potential violations, and attorney-client privileges and public records requests. And anybody that's had to deal with these, Bob's had to deal with them over and over for his clients over the years. They're a nightmare. And assume, here's what I will tell you, assume that any communications you have, either through email, through Instagram, Twitter, whatever, assuming I guess Instagram's not recoverable, it goes away right away, but Twitter and Facebook and the other ones.
No, it doesn't.
Oh, really? My son tells me Instagram goes away and you can't retrieve it, so he's lying to me.
No, once it's on the internet, it's out there.
Okay, all right. Well,
He might be telling you Snapchat.
oh, that's what I was thinking. My mistake,
not even
my mistake.
checking.
That's exactly what he was telling me. Okay, I was correct. I stand corrected. Bob's right. All right, but anyway, even without that, I just urge you to consider that everything you're putting out on social media is likely subject to a public records request, number one. Number two, can be discovered through litigation, through the discovery process. I deal with this all the time. It's a rare case that we can ever exclude that stuff unless it's an attorney-client thing. And can establish appearance of fairness liability and may also establish a violation of the Open Public Meetings Act if, a quorum is as part of the communication chain. It's just a parade of horribles, but just, my real generic advice is don't use social media for communicating about city business to people.
Okay.
I know that's hard. I know people are going, crazy. But just bear in mind the risks that inure to that. Appearance of fairness consequences, if there's an appearance of fairness violation, you don't disclose, etc., action is null and void, has to be all done all over again, okay? Potential claims for damages to both the city and the decision maker, may establish arbitrary and capricious decision, which can in itself lead to more damages, attorney's fees, embarrassment, all sorts of bad things. I've already talked a little bit about how to comply, but the big thing, disclose, and I will tell you, some attorneys have a difference of opinion on this, but if you make an appearance of fairness disclosure and you are challenged, my recommendation, it's your choice whether to step down or not. It's your choice. You cannot be forced to step down. Nobody can compel you to do it, but you need to think about the consequences, not just to yourself, but to the city and the decision. And, my recommendation, absent some other compelling circumstances, step down. Don't, unless you really feel like you're on solid ground and strong. If you do step down, don't stay in the room, leave. Because there's arguments get made all the time that because you're in the room, you're giving hand signals to the rest of the decision makers, or blinking or winking or whatever. It's just better to leave, okay? And then continue the hearing, or if need be, if there's a real continuing problem, cancel the hearing, continue it, restart it. I'm not going to go through this. We've talked about a lot of this, but I give you kind of summaries of open record hearings and closed record hearings. And what I want you to take away on this is simply that we've talked about a whole bunch of these, making the record, etc.
Mike, everybody's got the packet.
Okay.
And about 25 slides ago, we were gonna wrap it up.
Okay, sorry about that. All right, well, you know what? I'm done. How's that? Sorry, and I'm happy to stay around as long as anybody wants to and field questions. I thank you very much. I'm sorry it went over. I will tell you initially though, Jody asked me about 3 hours to do this for 3 hours. So I will tell you, I'm not like completely out arbitrary and capricious here. All right, thank you very much, all of you. Great questions. And
Mike, thank you. I mean, it's a lot. I mean, this is a half-day seminar at least.
Yeah.
And, I think what Glenn was saying, we were originally planning to start at 6. So,
yeah, no, and like I said, happy to stick around, and I'm happy to come back if you folks have specific, issues like, gee, we'd really like a primer on just open public meetings or this or that.
yeah, we do have the benefit of having Bob Sturbank, as you said, is very proficient with land use.
He's the man.
It's one of his areas of expertise. Bob, do you have one other comment?
Okay. I'll say it.
All right. All right, with that, if there's no other organizations that